that he intends to move these children away from their mother, and also that after 2 years, if she doesn't support or have contact, then she can be terminated and he can have these children adopted by another person.
Chanel Olsen versus Michael Lavanos.
The record of this matter is before the court on the plaintiff's motion for reconsideration. The plaintiff being Sarah Olsen. I'm sorry, the petitioner being Sarah Olsen, and the guardian of the plaintiff mother, Chanel Olsen. Mr. Gorski, attorney Ms. Gorski, is representing that guardian, and Ms. Sarah Olsen appears to be present with Mr. Gorski. In addition, attorney Corey Shimmick is present representing defendant Father Michael Lavanos. Mr. Lavanos is present. Way of history in this matter, the court originally entered an order, and perhaps the language of that order dated June 11th, 2024 was inappropriate because it did suggest that the grandmother, Sarah Olsen, was granted parenting time, and that was inappropriate because there was no petition for grandparenting time. It was simply for the grandmother to facilitate parenting time between the minor children and the plaintiff mother, who is currently residing in a nursing facility here in Monroe County. The court granted the defendant's motion for reconsideration and struck the order of July 30. Struck the order of June 11, 2024, which granted parenting time to Sarah Olsen. Subsequent to that, the guardian, maternal grandmother, filed a motion to reconsider that decision. So we're back here to where it began. The court, Mr. Gorski's reference that she clearly was not asking for grandparenting time, so perhaps we simply need a clarification of that order. And the court notes that when the parties were back for the court on June 11th, the guardian, Sarah Olsen, was to confer with the children's counselor as to the appropriateness of bringing the children to the nursing home in the presence of the plaintiff mother. So that seems to be the primary issue this morning. Has that been done, Mr. Gorski?
Your Honor, it wasn't clear who the children were seeing. Mr. Shimmick provided a report from the therapist yesterday, dated July 30. I believe he's forwarded that to Ms. Frazee. He sent it to.
Not seen it.
But my client has not spoken to the therapist. She has not.
And Your Honor, I was unaware that your previous secretary had retired, so I emailed it to her by mistake yesterday, but I just forwarded it to Ms. Frazee this morning, the report from the therapist.
In any event, so that's the primary issue. The only the time that the children have contact with the maternal grandmother is to transport the children to the nursing home. Can dad do that?
Yeah, yes, Your Honor.
Mr. Lavanos take the children to see their mother once the counselor says it's okay. Perhaps we should say for the record, the plaintiff mother, I think, consumed some pills. Is that correct? And she overdosed, and now she's in a. And perhaps her condition is improving, but she was in a coma for a period of time. I don't know if she's still in a coma, and obviously that could be difficult for the children to observe their mother in that condition. And the children, as I recall, are 7 and 6 years old. Is her condition improved? Is it appropriate for the children to see their mother in that condition?
Judge, it was a suicide attempt. She is not in a coma. However, she has not made a full recovery. There's a meeting scheduled for Tuesday of next week at 11 o'clock regarding her condition, and my client will know more at that time. She is responsive. For example, when my client talks to her about the children or things that are sensitive, she's aware of it and she will cry, but she's not engaged in a level where she could communicate, for example, to this court how she feels.
And Your Honor, my client would like to transport the girls to the visitations. And we did agree that he would not go in the room with them when the visitations do take place. But I think that we all agree that the girls need to be adequately prepared before the first visit, so that they're aware of their mom's condition or somewhat of what her condition is before they actually go and visit her. As of right now, they are aware that she is sick and that she's in the hospital. However, we do believe that the therapist, with the assistance of the therapist, they need to be adequately prepared before the first visit.
Mother communicate?
Not verbally.
Not verbally.
Okay, well, that's gonna be difficult for a 7 6-year-old if they can't talk with their mother.
Right.
But would she, again, we don't even know if she would know they're present. Any event.
She would know that, absolutely.
Okay, Ms. Gorski, you're asking the court to reconsider. The court's inclined to deny the motion reconsideration. You're asking that the court, not asking for grandparenting time, you're asking the court to permit contact between the sisters, with the stepsisters.
Half sisters. Chanel
Okay.
is the mother to all three girls, and my client actually has guardianship over that third child, McKenna.
Okay. Have you discussed that with, does she and Mr. Lavanos have any communication?
They used to. This incident has definitely caused a rift, and Mr. Lavanos does not respond to my client anymore.
It's unfortunate, Mr. Lavanos, for the best interest of your daughters, that they should have a relationship with their half sister. But the court doesn't believe it has authority to order that, Mr. Gorski, so the court was going to deny your motion for reconsideration. Ms. Brough, you could add that to this recommendation that the defendant's motion filed on behalf of Sarah Olsen to reconsider the prior decision of this court is denied. The recommendation further states that the first visit between the mother and children shall be arranged by the children's therapist. So she's going to arrange that, or she's going to recommend the contact. It's not real clear. She's not going to, the therapist not going to take the children to the nursing home, correct?
Correct. The intention is for the therapist to prepare them for the visit and to recommend when the first visit shall take place.
All right. Perhaps we can reword that to Ms. Brough, if you could, please, that the child therapist, that contact between the children and the mother will be arranged by the plaintiff father upon recommendation of the therapist. Further, father shall provide transportation for the visit, will not be in the present mother's room. The children shall attend North Point Elementary School in Southgate for the upcoming year. Any objection to that? Well, Mr. Gorski, I'm not sure if your client has any objection to.
She doesn't.
To object to that.
No. No, Judge, she understands the need for the girls to be closer to Mr. Lavanos's home, and based on the therapist's recommendation that they could use services through a school that, and Triumph doesn't provide those services, she has no objection. She believes it's best for the girls.
All right. Thank you. And lastly, Mr. Shimmick, you're asking for a change of custody.
That is correct, Your Honor.
What's the current, is there a petition that's before the court?
Yes, our original motion as to why we are here included a request for change in custody.
All right. Mr. Gorski, you're, well, I guess, I don't know who's representing the plaintiff mother.
It would be, my client is her advocate. So I guess I'm counsel to her guardian, and the guardian has the authority to advocate on behalf of her ward, Chanel.
Okay.
I understand, obviously, physical custody and parenting time. Mom currently has no parenting time and can't, pending the therapist's recommendation. But I do oppose a change of legal custody, because that would allow, as a practical matter, Mr. Lavanos to move to Alaska, or to substantially change Chanel Olsen's status or her ability to access the children and the children's ability to access her. And I don't believe that's in the children's best interest, particularly given his unwillingness to work with the plaintiff's advocate.
Understandable. And you know this court's opinion on physical custody. Right now, the parties share joint legal custody. Is that correct?
Yes.
Yes, Your Honor.
As a practical matter, that's it appears that the guard. I don't know if the guardian. You have to research that. I don't know whether the guardian should have input on emergency medical decisions for grandchildren or not. But again, it's more parenting time. So what's wrong with this court? I can parties agree that the defendant father will be the primary resident of the children will be with the defendant father.
I don't have an objection to that.
Shall not change the domicile of the children without the consent of the court. What's the objection to that, Mr. Shimmick? We're gonna spend a whole day arguing about that, and that's where it's gonna go. I'm telling you right now.
I understand, Your Honor. However, with joint legal custody, my
This
client.
court does not have to decide joint legal. This court does not have to. Well, I'm sorry. Yes, joint legal, we'll leave that in place, but we don't need to argue about physical custody, do we?
No, we don't need to argue about physical custody because I believe there's, and for a practical matter, there's been a change in physical custody already with the parenting time. But in regards to legal custody, my client is seeking sole legal custody given the change in circumstances. And as a technical matter, if there are any major decisions to be made, he can't go to Chanel mom and say, do you agree with this? So, what should he file a motion whenever there's a decision to be made, or can he make that decision on his own? He's kind of stuck if he does not have sole legal custody. So we are seeking sole legal custody in this matter, and that's why we asked it for an evidentiary hearing to be set.
Do you have any objection to a provision that the domicile of children shall not be removed from the state of Michigan without the consent of the court?
Or not be adopted by.
If sole legal were awarded to dad, are you?
Regardless of that,
That's
do you have any objection to the court entering an order that the domicile of the children shall not be removed from the state of Michigan without the consent of the court?
Do you have an objection to that?
Yes.
All right. Right, to Mrs. Gorski, as a brief these issues, does the guardian have the authority to make medical decisions on behalf of a grandchild?
Judge, I don't think that Chanel is in a position to object to decisions that Mr. Lavanos makes. I have two concerns, and that is, they seem to be founded based on the answer to the question that he just gave, that he intends to move these children away from their mother, and also that after 2 years, if she doesn't support or have contact, then she can be terminated and he can have these children adopted by another person. Those are my concerns, and sole legal custody would give him the ability to do that. I don't think that's appropriate. I don't think that that's fair to these children. And so I will brief that issue, and I will strongly advocate against sole legal custody.
All right. I guess rather than take an evident hearing, it appears to the court the primary issue. And even if the court awards joint legal, Mr. Shimmick, I'm sorry, if the court awards your client sole legal, there's nothing that prohibits this court from ordering that the domicile not be changed for state of Michigan. Would you agree?
Yes, I would agree, Your Honor.
All right. So with that, Mr. Gorski, I would ask that the parties think about that and confirm if in fact there's got to be some work with the language. The primary residence of the children shall be with the defendant father. The domicile of the children shall not be removed from the state of Michigan without the consent of the court. Perhaps I will address those issues. Perhaps we're making a lot of issues that don't need to exist. So at this point, rather than schedule an evidentiary hearing, do you want a date that Mrs. Gorski can I don't know if you want, is there any value in mediation, or do you want to brief that issue in terms of, does the guardian of the children have the right to participate in medical treatment decisions on behalf, emergency medical decisions on behalf of the children in her capacity as a guardian?
I think there's always a benefit to mediation, Your Honor, and I think that these two people who love these children need to get on the same page about what is in their best interest. My client is always going to have to defer to dad, and she understands that, but I don't think that these children are benefiting from the current situation.
Mr. Shimmick, an objection to mediating this issue of the change of custody?
No objection, Your Honor.
Right. Ms. Bard, do you have a list of mediation dates and times available?
Yes, Your Honor. I have Thursday, September 12th in the afternoon.
That works for me.
I can do that.
1:30?
Yes, Your Honor.
That with Mr. Walker or Ms. LaPrade?
That's with Miss LaPrade.
All right. All right, if you could just put that in this recommendation to Ms. Brower, and the court will be the parties should meet with Ms. LaPrade on that date and time, and subsequently appear before the court for review. If in fact there's no resolution, the court at that time will schedule a hearing, Mr. Shimmick and Mr. Gorski. But yes, the court's inclined, no matter what we do, is to order that the defendant father prohibited from changing the domicile of the children from the state of Michigan without consent of the court. I think that's gonna be a starting point. I don't know why we can't, with that, work around these other issues.
Okay, understood, Your Honor.
Because, yeah, what if mother improves? We always hope that someone will improve their condition. She can be active in their daughter's lives.
Of course.
If dad's moving out west, I mean, that's going to destroy that. So with that, the children shall attend North Point Elementary School in Southgate for the upcoming year. For the prior order, the children will continue to be in primary possession of the plaintiff father. The court will deny the motion for reconsideration filed by Attorney Gorski on behalf of the guardian, Sarah Olsen. And father shall facilitate visitation of the children with their mother upon recommendation of the children's therapist. So obviously, Mr. Lavanos, it's important that as mom improves and talk with the counselor about the children, slowly talk with them about when's the right time for them to see their mother. And obviously, you have to describe to the therapist the mother's condition, that she's nonverbal right now. At some point in time, children need to see their mother.
We've already talked to the therapist about it. We're kind of like working towards it.
Okay. And to try to keep an open mind too. Do they ask about their stepsister, their half sister?
Sometimes.
Well, maybe invite the stepsister over to spend a day with your daughters. I mean, you got to think out what's best for your daughters, not what's good for you or what you personally feel, but what's best for your daughters. That's what you got to be guided by. So the court would encourage that.
Okay.
All right. Anything further than this morning, Mr. Gorski or Mr. Shimmick?
No, thank you, Your Honor.
No, nothing further.
Right, that will conclude this matter. Thank you, Ms. Brower, for your assistance. I know didn't realize we had things every 15 minutes, so I know
You're
Thank
welcome.
Have a great day, everybody.
Thank you.
Thank you.
You want us to believe that you just bragged in order to convince this woman to marry you, that you had money, that you had businesses, that you had a nice apartment, and then when it didn't work, you let it all go to hell? Is that what it is? You lied to her?